let's dive into a little bit of tax issues. The word tax can mean so many different things. So I want to get more specific. Most estates don't have an estate tax issue because the estate tax exemption amount is so high, and California has abolished the estate tax. And so right now, someone can give away up to, how much is the exemption for 2025?
For 2025, it's 13,990,000. I heard that it's going to be going to an even 15 million as of January 1st. So yeah, so for a married couple, it's 29 million. What is that? 800 and something $1,000, and currently, and it's going to be 30 million next year.
It's a lot of money. I don't know. You probably do, but I don't know anybody with this kind of money.
Yeah, I do have clients that are north of that. But what people, and this actually gets into the topic, what people fail to recognize is that those are the numbers for U.S. citizens and U.S. green card holders who do not intend to leave the United States. If you are a non-resident alien, if you're working here on a visa, for example, or you're a college student here on a student visa, the exemption drops to $60,000 per person.
Big difference, $60,000 to almost 14 million.
The $60,000 exemption applies to both non-resident aliens and resident aliens who are not green card holders or who are not U.S. citizens. So, for example, someone who is here on a work permit or on a student visa is a resident alien, but unless they've applied for a green card, they're not a green card holder, and obviously they're also not a citizen. A non-resident alien is a person who does not live in the United States and does not have the right to work or remain in the United States. So, for example, if I were a U.S. citizen and my spouse, or even a green card holder, if I come over to the United States to work, my spouse accompanies me, and he's not going to work in the United States. He would be a resident alien, but could, if he decided to stay back in whatever our home country was, he would be a non-resident alien and just be coming over on like a tourist visa every so often to see me. So it is primarily someone who neither works nor lives in the United States, and has not filled out the paperwork and been accepted as a green card holder, or who is not a U.S. citizen.
Now, this might get confusing about, there's a presence test for the income tax to apply. And it's, basic, there's a number of days, it's 183 days or whatever it is,
right,
for a number of years. Does that apply here to whether or not you're a resident? And does that matter to the estate tax?
So this is where things get a little slippery. The short answer is no, not really. For estate and gift tax purposes, we don't look at residence as much as we look at the concept of domicile, which you might remember from your first year civil procedure class in law school. And the distinction, or a distinction, is that you can have many places in which you reside. You can have a residence in California, you can have a residence in Hawaii, you can have your place in Paris.
Sounds nice.
Yeah. The little island that you bought off the coast of the Caribbean.
Sure,
Belize. Yeah. All of those are your residences, but you only have one domicile. And the domicile is the place that you consider your home. So you could live, even as a green card holder, you could live in the United States for 30 years. But if you still think of that little island off of the coast of Belize as your home, you are not a domiciliary of the United States, and technically, you only qualify for that $60,000 exemption.
Is this an intent requirement, or is this what is domiciliary or domicile?
Domiciliary, yeah.
Yeah.
Yeah, it is a question of intent. Where do you intend to live? Where do you intend to die? Um, uh, even if you don't live there, um, at the present, it's what do you really consider your home? And it is a slippery concept. I guess the landmark case is a gentleman who, and this goes back to like the 30s or the 40s. He had been in the United States for years and years and years. He had a business in the United States. His wife and I think his kids were in the United States. He went back to, uh, I believe it was Iran, to visit his dying mother. And he got sick while he was there and couldn't travel back to the US and ended up dying in Iran. He had a substantial estate by 20s or 30s or 40s standards. And when uh, his estate was being settled, the IRS basically said, wait a minute, you are not, or he was not a domiciliary of the United States. So he's only got this $60,000 exemption. And it went all the way up to the Supreme Court. The attorneys had to lay out a case for why he was a domiciliary of the United States. And of course, the IRS wanted its tax money. So they were laying out all of the reasons why he was not. Um, he did end up, or his family did end up, proving that he was a domiciliary because he intended to return to the US. He was just prevented from doing so because he got sick.
And some other countries, there's a difference between an estate tax, which most people are familiar with, versus an inheritance tax. Can
Correct.
you shed some light on the difference between those?
Yeah, the simplest way that I find to explain the difference is that the estate tax is really paid by the decedent, by it's paid out of the assets that belong to the decedent. An inheritance tax is paid by the recipient. So let's assume that I've got an estate where I've got, again, let's call it $2 million, and I've got one kid that lives in the United States, U.S. citizen living in the United States. Well, actually, I guess for today's world, if we're dealing with estate tax, we've got to have more than a $15 million estate if it applies to a U.S. citizen. But let's assume, or to a green card holder. But even though the estate might not be subject to estate tax in the United States because it's well below the $15 million, if you're living in a country that has inheritance taxes, and let's say you're sending $500,000 to that country, that is so, and when it comes into the country, the person who's receiving the money is required to indicate what the source of the money is. So in this case, it's an inheritance from Great Aunt Martha in the United States. That is subject to inheritance tax, even though it's not subject to estate tax in the United States. Where it gets particularly messy, shall we say, is in the larger estates where, for example, there's been estate tax paid in the United States, and then the recipients also have transfer tax. None of the treaties, to the best of my knowledge, have an offset for estate tax to inheritance tax issues. So you could very well end up paying an estate tax in the United States and also have the recipients be required to pay an inheritance tax when they receive that money in the other country. And please don't ask me which countries have inheritance taxes because I don't have it memorized.
But I think the important thing to understand here is that the estate tax is different from an inheritance tax.
That is correct.
The taxpayer is different. And if the US has an estate tax treaty that offers relief with another country, that may not be applicable to the inheritance tax.
It probably will not be inherited.
Applied to the inheritance tax.
Thank you. Applied to the inheritance tax.